Ready, start. The last question is the present case a case of an exceptional nature in which the learned judge should have exercised his inherent jurisdiction under Section 561-A CRPC in respect of the observations complained of by the state government? If there is one principle of cardinal importance in the administration of justice, it is this: the proper freedom and independence of judges and magistrates must be maintained, and they must be allowed to perform their functions freely and fearlessly and without undue interference by anybody, even by this court. At the same time, it is equally necessary that in expressing their opinions, honorable judges and magistrates must be guided by considerations of justice, fair play, and restraint. It is not infrequent that sweeping generalizations defeat the very purpose for which they are made. It has been judicially recognized that in the matter of making disparaging remarks against persons or authorities whose conduct comes into consideration before courts of law in cases to be decided by them, it is relevant to consider within bracket A whether the party whose conduct is in question is before the court or has an opportunity of explaining or defending himself within bracket B, whether there is evidence on record bearing on that conduct justifying the remarks, and within bracket C, whether it is necessary for the decision of the case as an integral part thereof to animadvert on that conduct. It has also been recognized that judicial pronouncements must be judicial in nature and should not normally depart from sobriety, moderation, and reserve. Double inverted comma. No doubt what the High Court has done in the present matter is to direct the fixing of the license fee, keeping in mind the judgment of the court in T. Krishna Kumar within bracket Supra. The appellant had no opportunity to explain whether T. Krishna Kumar within bracket Supra had application to the transaction in question or not. Further, to direct the Chief Vigilance Officer to hold an inquiry in the double inverted comma matter relating to leasing out the land to the appellant double inverted comma close was not warranted on the facts and circumstances of the case. Directions of this nature for a fishing and roving inquiry can seriously impinge upon reputation and character of the parties. The directions extracted in para above have rendered the appellants worse off in their own reputation. In Ashok Kumar Nigam versus State of UP, this court held as under double inverted comma 2 dot. Appearing for the appellant, Mr. D.K. Singh strenuously argued that the High Court had misdirected itself in issuing a notice of enhancement of the punishment awarded to the appellant. He submitted that by doing so, the High Court had placed the appellant in a worse off position simply because he had challenged the punishment awarded to him. That was, according to Mr. Singh, legally impermissible. In support of his submissions, Mr. Singh placed reliance upon two decisions of this court in Pradeep Kumar versus Union of India and others within bracket 2005 bracket close 12 SCC 219 and Ramesh Chandar Singh versus High Court of Allahabad and another within bracket 2007 bracket close 4 SCC 247 double inverted comma close.